Part 1. Negotiable Instruments. Chapter 1. General Characteristics and General Form of Bills, Notes and Checks. Section 1. Introductory. The most common forms of commercial paper used today in commercial transactions are promissory notes, bills of exchange and bank checks. At present these constitute the medium of exchange for about 90% of all commercial transactions. In this treatise these three instruments will be considered, and it is essential in the beginning that a clear idea should be had in a general way of the characteristics and form of such instruments. Section 2. Form of promissory note. The following is a simple form of a promissory note. $200 New York City, New York. December 1, 1908, 6 months. After date I. Promise to pay to the order of William Redding. $200. At the First National Bank. Value received. No. Due. John Morris. The following is a form of a promissory note which is common in some jurisdictions. $200 Indianapolis, Indiana, December 1, 1908, 6 months. After date I promise to pay to the order of William Redding. At the Eagle National Bank, of Indianapolis, Indiana. $200. With 5% attorney's fees, upon the principal of this note. Value received, without any relief whatever from valuation or appraisement laws of the state of Indiana, with interest at the rate of 8% per annum after maturity until paid. The drawers and endorsers severally waive presentment for payment, protest, notice of protest, and notice of non-payment of this note. John Morris. Section 3. General Characteristics of Promissory Note. Let us examine the parts of the above instrument in a general way, commencing with the upper left corner of the instrument. A. We note first the figures, $200. This is to indicate the amount of the note, and being in figures is more quickly grasped than if in writing. If there is a conflict between the figures and the writing below on the instrument, the writing will control. B. The place, Indianapolis, Indiana, shows the place where this contract to pay is entered into, and as the laws of the various states differ as to the requisites of such a contract and as to the enforcement of the same, it is generally essential that the place of entering into the agreement should be set out so that it may be clear just what law governs as to the contract or instrument. C. The date, December 1, 1908, is likewise essential so as to determine when the note is due and from what time interest is to be charged, and whether or not the collection of the instrument is barred by the statute of limitations. D. The time, 6 months after date, indicates the period of time for which the instrument is to run or indicates when the promise on the instrument should be fulfilled. E. The promise, I promise to pay, is an absolute promise to do something, that is, to pay. It does not read, if so and so happens or does not happen I promise to pay, but it is connected with no conditions of any nature. F. The words to the order of, signify a promise to pay it to the order of any who may be designated. We shall consider in a subsequent chapter whether such words are absolutely necessary and whether they should always be in the form indicated. G. The name, William Redding, is the person to whose order something is to be paid and he is known as the payee. H. Then follow these words, at the Eagle National Bank of Indianapolis, Indiana, indicating where the note is to be paid. I. The amount $200, indicates, as the figures did, the sum promised to be paid. The same being in writing cannot be so easily altered, and since it takes longer to write the words than the figures, the words are more likely to be accurate. J. The phrase, with 5% attorney's fees, indicates that if William Redding, the payee, or anyone to whose order he should make it payable, shall find it necessary to employ an attorney to collect the amount, 5% additional will be paid by the party to the instrument who makes it necessary that an attorney should be employed. K. The words value received, indicate that a consideration was given for the note, but most jurisdictions hold that these words are not necessary since a consideration is presumed. 1. The phrase, without any relief whatever from valuation or appraisement laws, shows that if the note is not paid when it should be and suit is brought and judgment recovered, then the one against whom judgment has been recovered waives any rights that he may have as to requiring that the property taken to satisfy the judgment, shall be valued or appraised by persons appointed for that purpose. and the property taken may be sold at any price. Thus the delay for evaluation and appraisement is avoided. The words, with interest at the rate of 8% per annum after maturity until paid, show what interest is to be paid by the maker in addition to the $200 if not paid when due. This interest will be calculated from June 1, 1909, the date of maturity, up to the time the note is paid. The percent set out is 8%, and we shall see in a later part of this work that different states have different laws governing the rate of interest which may be charged. By the words, the drawers and endorsers severally waive presentment for payment, protest, and notice of protest and non-payment of this note is meant that the drawers, or persons who make the note, and the endorsers, or persons through whose hands the note passes and who write their names on the back of it, waive any rights that they may be entitled to because the instrument when due was not properly presented for payment and the proper notice was not given to other parties who should have notice of the non-payment and other facts in connection therewith. Thus if such rights were not waived and William Redding should endorse the note, that is, write on the back of the note an order that it be paid to John Graham, and John Graham in turn should endorse it, that is, order it to be paid to James Spencer, and on June 1, 1909, when the note became due, John Morris, the maker, refused to pay James Spencer, the holder. Then, in order for James Spencer to recover from John Graham on the note, it would be necessary for him to present the note to John Morris for payment and then notify John Graham of the refusal of John Morris to pay and notify him that he, James Spencer, expected to look to him for the payment of the note. In other words, it would be necessary to present the note to John Morris for payment unless the endorsers waived presentment for payment, and it would be necessary to notify the endorsers of the non-payment unless notice of non-payment of the note was waived. The contract of John Graham is that he will pay the note provided it is presented to the maker, John Morris, and in case John Morris does not pay it and he, John Graham, is notified of that fact, then he, John Graham, will pay it. In case the law should require the note to be protested in order to bind the drawers and endorsers, it would be necessary for a notary public to take the instrument to John Morris, and John Morris would state to the notary public that he refused to pay it. The notary would make out a paper stating that the instrument had been dishonored, and that he had protested it for non-payment, and to this statement he would attach his seal. This is the protest. It is not the notice of the protest. The protest then is a solemn declaration in writing made by the notary public that the instrument has been dishonored by a refusal to pay it. At the trial, this statement of the protest by the notary would be good proof that the instrument had been protested and the notice had been given to John Graham. After the instrument is protested, as above set out, the notary would send notice to all those parties on the instrument whom the owner desired to hold responsible, which notice would state that the instrument had been presented for payment, that payment had been refused, and that the instrument had been protested for non-payment. The stipulation in this instrument waiving protest and notice of protest waives these rights, otherwise it would be necessary for James Spencer, the holder, to take these steps in order to recover from John Graham, an endorser, in case the instrument was one which the law required to be protested. The contract of the endorser under such circumstances is that he will pay the instrument provided the maker refuses to pay it and the owner of the instrument protests it and gives notice of that fact. John Morris is the maker or drawer of this note. He is the one who promises to pay it in the first instance. The note may be signed by more than one, as we shall consider more fully in another part of this work. Section 4. Form of Bill of Exchange. The following is the ordinary form of an inland bill of exchange. $120 Chicago, Ill, December 1, 1908. 30 days after date. Pay to the order of John Matlock. $120. Value received, and charge the same to account to Irving Dean, Jamestown, N.Y. Henry Hamilton. Section 5. General characteristics of Bill of Exchange. Let us examine this instrument, considering, however, only those formal and essential parts which are not found in the promissory note. There are three parties to this instrument. John Matlock is the payee, Henry Hamilton is the drawer, and Irving Dean the drawee. Irving Dean, the drawee, becomes Irving Dean, the acceptor, by writing accepted and his name, or words of similar import. across the face of the instrument. Section 6. Form of a check. The following is the common form of a check. Detroit, Michigan, December 1, 1908. Number 15. The Eagle National Bank. Pay to the order of Albert Carter. $200. 200. John Marsh. Section 7. General characteristics of check. A check is the most common instrument, and in explaining the other two instruments all parts of this instrument have been explained. Albert Carter is the payee and John Marsh is the maker or drawer, and the Eagle National Bank is the drawee.